Okay. I call cause numbers 10,694 and 10,823, each case being styled the state of Texas versus Misty Dawn Doty. These are hearings, pretrial hearings in revocation cases. These hearings are being conducted by remote video teleconferencing technology using the Zoom protocol. These hearings are also being live streamed on the court's YouTube channel in order to comply. All of this is being done in order to comply with Supreme Court orders and Office of Court Administration orders and directives requiring that our hearings be conducted remotely rather than in person. The live stream on the court's YouTube channel is to comply with directives from Supreme Court, Texas Supreme Court, and Office of Court Administration, suggesting that broadcasting and live streaming on the court's YouTube channel would provide access to the public in order to comply with the Texas Constitution Open Courts paragraph. I don't really believe that paragraph requires that, but that's a different story. We are complying with those requirements. I would also announce that the court reporter for the official court reporter for the 132nd District is participating in this remote hearing, and we'll make a transcription of these proceedings, just like he would do if we were in an in-person live hearing, which we are not. We are live, but virtual through the Zoom protocol. No one is permitted to record any portion of this hearing electronically or otherwise. To do so would subject someone to being held in contempt of court for violating that order. There is one exception. That exception is for the official court reporter, who, as I mentioned, is taking a transcription of this matter. All of that being said, for purposes of pretrial in these two matters, what says the state?
Ready, Your Honor.
And defense?
Present, ready, Your Honor.
And we'll note that defendant Misty Dawn Doty is also present with us in this virtual courtroom. Good afternoon, good afternoon, Ms. Doty.
Good afternoon, Your Honor.
Do we have any pretrial matters to take up in Ms. Doty's cases at this time? Mr. Smith.
Judge, the only matter for the state would be to request a setting on the probation case, the motion in that case.
One is the probation and one is the new indictment. Is that correct?
That's right, Your Honor.
The new indictment is in cause number 10,823. And so we're having a pretrial hearing in that case as well. And the motion to revoke probation is in cause number 10,694. And our pretrial hearing is in that case is on our motion to revoke docket. Ms. Fay, do you have any pretrial matters to present at this time on behalf of Ms. Doty?
No pretrial matters, Your Honor.
When might we set that for a hearing?
Has the new indictment charge been set for a docket?
Yes, it is on this month's docket.
And when is that?
Tomorrow. But if you would like, we will allow you and Ms. Doty to participate in the docket setting today at this time instead of coming back again tomorrow.
Okay.
Is that something you would like?
Yes, sir.
And everybody knows we do everything to satisfy you. And so we will have the pretrial hearing in the case styled State of Texas versus Misty Dawn Doty, numbered 10,823. So do we have any pretrial matters in that case either, Ms. Fay?
Nothing from the defense, Your Honor.
All right, back to the setting. On the revocation case, when I'll give y'all an opportunity to suggest dates that would fit all of your schedules.
I'm sorry, my January is really bad. I have the 22nd of January is open. We'll be by Zoom, correct?
Yes, ma'am.
Okay, so the afternoon of the 25th, I can do.
What does the district attorney's schedule look like on the 22nd? And I realize you may be in trial preparation then, but.
Well, we're just going to have to work around that, Judge. For me, the 22nd is open for me. I'll make time to do this. I would prefer to have this hearing on the 22nd rather than the 25th.
Certainly. Morning or afternoon?
The full day available, so whatever is better for.
How long will it take to present this?
Judge, I don't think it would seem to me from looking at my motion just now, probably the state's evidence wouldn't take more than an hour to present.
Same for the defense, Your Honor.
I would prefer a morning.
However, I do believe that we're in negotiations on a plea, and so I would hope that by that point we would have a plea available.
Okay. Mr. Smith, you were saying you prefer a morning setting?
Yes, sir.
And that fits your schedule, Ms. Fay?
Yes, sir.
Does that work on your schedule, Ms. Doty?
Everything works on my schedule, so I'm good, Your Honor.
All right. Then let's set it for 9:30 on January 22nd. And plea cutoff is the 15th on this month's jury docket. And I do anticipate us having a jury trial. But this case is also down the docket, so to speak. And we have other cases that are going to go to trial. So
Okay.
I'm not going to be worried too much about plea cutoff in Ms. Doty's case
Okay.
this month. All right. Is there anything else then that we need to take up in either one of these cases?
No, Your Honor.
No, Your Honor.
Then this will take care of your responsibilities to appear for pretrial tomorrow.
Thank you, Your Honor.
And we will send out a notice to you, Ms. Fay, of the setting on the 22nd. Anything else? If not, we'll be in recess. Thank you.
Thank you.
Thank you.
Thank you, Ms. Doty.
Thank you.
Hey, Misty, we're going to hear another one. So if there's someone that you can get their attention to switch people out.
Okay, let me.
Did we have Mr. Pesina going over to the jail to do
He
his?
was at the jail, but they were telling him they didn't know what he was talking about. So my legal assistant called again, and I think she's trying to work it out over there. I think he may be ready.
We don't have too many people that are just beating on the door wanting to get into the jail.
Like, what are you doing here?
I did also clear
Crazy
it up.
time. Do what, Kayla?
I cleared it up as well, and I was told Mr. Pesina was expecting you to be there with him.
Let me get them.
That's not
Thank
what
you.
was told to him.
That'd be the first time ever. Or they didn't listen to the court coordinator, which would not be the first time ever. Yeah. Good afternoon, Mr. Pesina.
Good afternoon.
Because we are doing this by the Zoom teleconferencing, you are permitted to take your mask off.
Oh,
And there are some papers that have been presented to us with your signature on them. The court reporter has just opened up his screen, and he's going to talk to you about your signature and administer an oath to make sure, if it is the circumstance, that you are swearing to the documents that you've signed. So I'll let Mr. Hanshu visit with you.
like I can't hear.
He's muted.
Can you see this stipulation of evidence?
Yes, sir.
Did you go over this with your attorney?
Yes, sir.
Is that your signature?
Yes, sir.
Do you swear that everything in there is true?
Yes, sir.
Thank you.
It just muted my Zoom without muting the laptop's mic. All right, I call cause number 10,624 for the case style, the state of Texas versus Braulio Alejandro Pesina. The scheduling of this matter and the plea papers that have been presented to me indicate that the defendant desires to enter a plea of true to the allegations in the state's motion to revoke probation, and to do so pursuant to a plea agreement between defense and state. Now, let me also mention that this hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. We are conducting the hearing in this manner to comply with Texas Supreme Court orders and Office of Court Administration orders and directives. We are also complying with the directives from the Office of Court Administration to make this hearing available to the to the public. And we are doing so by live streaming the proceeding on the court's YouTube channel, thus providing access to the public just as they would have if we were having an in-person hearing and they walked into the courtroom and sat down in the gallery. But as usual, there's not anybody in the gallery. There's not anybody. It does not appear that anybody is observing on YouTube channel at this time. Because this is being live streamed, I further announce that all parties are expressly prohibited, whether a party or an observer, all parties are expressly prohibited from recording this proceeding or any portion of it, whether telephonically or electronically or otherwise. Anyone violating that order is subject to being held in contempt of court. With those statements on the record, for purposes of a plea agreement hearing, what says the state?
State's ready, Your Honor.
And defense?
Sitting ready, Your Honor.
And the record will reflect that Mr. Pesina is present with us as well by the Zoom video teleconferencing technology. Also present is a member of the Adult Probation Office, Mr. Chris Oliver. Mr. Pesina, are you Braulio Alejandro Pesina?
Yes, sir.
Have you received a copy of the motion to revoke probation that has been filed by the state's attorney in this case?
Yes, sir.
Do you understand that that motion to revoke probation alleges that you have previously been placed on probation in this cause, namely 10,624? It alleges that you have violated the terms of that probation, and it specifies what the motion claims to be your violations. And it asks that your probation be revoked and that you be sent to the penitentiary. Did you realize that that's what the motion to revoke probation was saying?
Yes, sir.
Then understanding the allegations and what the petition to or motion to revoke alleges, to that motion to revoke probation, how do you wish to plead? True or not true?
True.
Do you understand that you do not have to enter a plea of true? You have the absolute right to enter a plea of not true. And further, you have the right to not have it held against you or used against you just because you have exercised your right. Do you understand that?
Yes, sir.
You also have the right to have a reasonable time to receive the allegations and prepare to meet the allegations in the motion to revoke probation. We presume that 10 days is a reasonable time. We base that upon language in the time that a person is entitled to before being required to face the charges in an indictment. That time frame is 10 days. It has been more than 10 days since you have had the motion to revoke probation and had it served upon you. I say that from docket entries and from the court's own recollection. Let me stop there and go to a certain document entitled waiver of 10 days. I've been handed a document entitled waiver of 10 days that has the same signature on it that you identified as your signature when you talked to the court reporter before we got on the record. Do you remember signing the document entitled waiver of 10 days?
Yes, sir.
Do you understand that it means you're giving up any opportunity to have additional time to prepare, and instead you're saying, okay, you're ready to go forward on your case this afternoon? Did you understand that?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Ms. Fay, your signature's on this document as well. Are you joining your client in the waivers discussed?
I am, Your Honor.
All right, I will accept those waivers and we will proceed. Mr. Pesina, there are other rights and admonitions I want to cover with you at this time. Let me tell you that I am aware that a plea agreement exists in your case, but I tell you, I do not have to follow your plea agreement under the law. But by my policy, I will follow the plea agreement, or if I decide not to follow the plea agreement, I will first tell you that I don't follow it, and then I will give you the opportunity to withdraw your plea of true. If I don't follow your plea agreement, you don't have to plead true. Do you understand that?
Yes, sir.
Next, I ask you a question I'm required by law to ask. Are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Fresno, California.
And my next question asks, do you consider yourself presently, that is at this time, to be mentally competent?
Yes, sir.
Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to talk to your lawyer and discuss with your lawyer the facts that make up this case? Discussing both the charges and the facts. Have you been able to assist and cooperate with your attorney in preparing to meet these charges?
Yes, sir.
Ms. Fay, do you believe your client is mentally competent?
I do, Your Honor.
And have you had opportunities to visit with Mr. Pesina either remotely or in person?
I have.
I want to, that was poorly worded on my part. Have you also, does that include opportunities to meet with Mr. Pesina in person?
Yes, Your Honor.
All right. Do you believe your client, Ms. Fay, do you believe your client is mentally competent?
I do.
All right, I accept that representation. It's obvious to the court that Mr. Pesina is in fact mentally competent. I base that upon the personal appearances he has made before this court, as well as the Zoom teleconferencing hearings that we're having today. Mr. Pesina, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
And let me tell you why I asked that question, because I'm not trying to suggest you wouldn't be or shouldn't be satisfied with her work. Instead, I just asked that question so you would have a chance to tell me if you were not satisfied, if you thought her work was somehow deficient or legally ineffective. My question gives you that chance to tell me of those things. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you've received from Ms. Fay in these matters?
Yes, sir.
All right, those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
Objection.
Mr. Pesina, let me talk to you for a moment about the stipulation of evidence. And in doing so, I will mention some other rights that belong to you that are at least referenced in the stipulation. First, I tell you that the state is required to produce some evidence of your guilt even though you're entering a plea of true to the allegations. That gives you a chance to see all of the people who might testify against you. We call that the right to confront them as you see them testify and listen and hear them testify. But this stipulation of evidence says you're giving up your right to require the witnesses to be present so you can see them and hear them as they testify. Did you realize you were giving up the right to confront the witnesses when you signed the stipulation of evidence?
Yes, sir.
The stipulation also says you're giving up your right to remain silent, as well as your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself. Among other things, you're admitting that you have been placed on probation. You're admitting that you have violated the terms of your probation. And you are acknowledging, I may have already said that, you're acknowledging that all of the material allegations in the motion to revoke probation are true, that you committed the violations just like it's alleged. Did you realize you were doing those things when you signed the stipulation of evidence?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this case.
State rests, Your Honor.
Rest and close, Your Honor.
State closes.
Mr. Pesina, now let me talk to you about your plea agreement that's been presented to me. I want to make sure I understand it the same way you understand it. The plea agreement says to me that you will enter a plea of true to the allegations in the motion to revoke probation, as you have done. It says that's going to result in your probation being revoked and you being sentenced to probation, to incarceration in the Texas Department of Criminal Justice for a period of 5 years. The plea agreement says you will owe reimbursement fees totaling $620, as well as owing restitution in the sum of $4,733.57. Now, those are parts of the plea bargain agreement, but there are other parts as well. Another part says you will be given back time credits for 4 days. It says that rather than spend 5 years in the penitentiary, if you apply for what we sometimes call a shock probation, we will grant you that request. I'm sorry. It says further that if you don't violate the terms of TDCJ rules, you can apply for what we call a shock probation, and the state will not object to it after 120 days. So that means you'll have to wait 120 days, pardon me, before asking for a court appointed, before asking for a shock probation hearing. Do you understand that?
Yes, sir.
Goodness. The plea agreement says that you'll be ordered to pay reimbursement fees totaling $620, restitution totaling $4,733.57. I already mentioned the 4 days back time credit. The plea agreement also says you're giving up your right to appeal, which ordinarily you have the right to do, appeal. But if you give up your right to appeal as a part of the plea agreement, that provision means what it says, and you will not be able to appeal if I follow your plea agreement. Do you understand that?
Yes, sir.
Have I stated the plea agreement the way you understand it to exist?
Yes, sir.
I'm not sure I even said this. Do you understand that the plea agreement calls for 5 years confinement, subject to the possibility of getting out after 120 days on shock probation?
Yes, sir.
All right. Are you asking me to approve all of the terms of your plea agreement?
Yes, sir.
Ms. Fay, have I stated the plea agreement accurately as you understand it to exist?
Your Honor.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right, I announce that I will accept and follow the plea agreement as presented and discussed. So, based on that, based upon your plea of true, Mr. Pesina, and based upon your stipulation of evidence as well as your plea bargain agreement, in cause number 10,624, style the state of Texas versus Braulio Alejandro Pesina, I hereby find that you have violated the terms of your probation as set out in the motion to revoke probation. That pronouncement that you have violated the terms of your probation and that your probation should be revoked having been made, do you know of any legal reason why a sentence should not be pronounced at this time? Mr. Pesina.
No, sir.
Then, following your plea bargain agreement, I hereby sentence you to serve 5 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order you to pay reimbursement fees totaling $620 and order you to pay restitution in the sum of $4,733.57. I give you time credits of 4 days, and I will state again on the record that I am aware of the plea agreement that will allow you to apply for shock probation, what we call shock probation, after 120 days, provided you follow all the rules of TDCJ. Mr. Pesina, do you have any questions about this judgment and sentence I have just pronounced?
No, sir, Your Honor.
Then those will be the orders of the court. Your thumbprint has been acquired and placed on the, and exists on the judgment that's been handed to me that I'm signing. You will be remanded to the custody of the sheriff's office. And that will conclude our hearing. Thank you, sir.
Thank you.
Ms. Fay, do you have anything else?
No, sir.
Mr. Oliver, is there anything else that I need to cover for you?
No, sir.
I didn't take Mr. Fay off of here. I mean, Mr. Pesina off of here. I guess the jail did it, or he did it himself. I never saw anybody approach him.
I believe there was somebody standing to his right the whole time he was in there.
Okay, good enough. That concludes our hearing, and that concludes all of our business that I have with Ms. Fay. Is there anything else, Ms. Fay, before we sign everybody off?
No, sir. Thank you.
Thank you, Mr. Smith.
All right, we'll see y'all.
We're in recess.